Good day everyone, especially to Madam Season. We are the Group 3 and we are going to discuss the Module 6 and Module 7. Here are the members of Group 3. Yours truly, Haro, Datulaita, Sinahon, Baring, Dolotina, Tambilawan, Bayron, and Pilahi.
Our report is all about the probation and parole administration and the forms of executive clemency pardon. First, we are gonna tackle the probation and parole administration. The learning targets are discuss what is probation and parole administration, identify the functions of probation and parole administrations, legal basis of probation and parole administrations, and explain the organization structure of probation and parole administration. The overview. The Parole and Probation Administration is an attached agency of the Department of Justice which provides a less costly alternative and imprisonment offenders who are likely to respond to individualized community-based treatment programs. So the Probation Administration was created by virtue of Presidential Decree Number 968, the Probation Law of 1976, signed by then President Ferdinand E. Marcos to administer the probation system. Under Executive Number 292, the Administrative Code of 1987, which was promulgated on November 23, 1989, the Probation Administration was renamed Parole and Probation Administration and given the added function of supervising prisoners who are, after serving part of their sentence in jails, are released on parole pardon with parole conditions. First, the Executive Order 292. The Administrative Code of 1987. The Parole and Probation Administrations herein after referred to as administration shall have the following function. Number 1. Administer the parole and probation system. Number 2. Exercise general supervision over all parolees and probationers. Number 3. Promote the correction and rehabilitation of offenders. And the last, such other function as may hereafter be provided by law. So it is effective on August 17, 2005 by virtue of Memorandum Agreement with the Dangerous Drugs Board. The administration performs another additional function of investigating and supervising first-time minor drug offenders who are placed on suspended pursuant to Act Number 9165.
Under the Probation Law of 1976, PPA is mandated to promote the correction and rehabilitation of an offender by providing him with individualized treatment, provide an opportunity for the treatment of a face offender, prevent the commission of offenses. Mission: the Parole and Probation Administration (PPA) mission is to rehabilitate probationers, paroles, and paldones, and promote their development as integral persons by utilizing innovative interventions and techniques which respect the dignity of and recognize its divine destiny. Vision: model component of the Philippine correctional system to enhance the quality of life of its clients through multidisciplinary programs and resources. Goals: the administration's program says to achieve the following goals: promote the reformation of criminal offenders and reduce the incidence of recidivism, and provide a chapter alternative to institutional confinement of first-time offenders.
Structural and personnel organization. The administration shall be headed by an administrator who shall be immediately assisted by a deputy administrator. The administrator and deputy administrator shall be appointed by the president and upon the recommendation of the secretary. The administrator shall receive an annual salary of at least 40,000 pesos. Their powers and duties shall be to act as the executive officer of the administration, exercise supervision and control over all probation officers. Make annual reports to the Secretary of Justice in such form as the latter may prescribe concerning the operation, administration, and improvement of the probation system. Promulgate, subject to the approval of the Secretary of Justice, the necessary rules relative to the methods and procedures of the probation process. Recommend the Secretary of Justice the appointment of the subordinate personnel of his administration and other offices established in this degree, and generally perform such duties and exercise such powers as may be necessary or incidental to achieve the objectives of this degree. Assistant Probation Administrator. There shall be an Assistant Probation Administrator who shall assist the administrator perform such duties as may be assigned to him by the latter and may be provided by law. In the absence of the administrator, the assistant probation officer shall act as head of the administration and shall receive an annual salary of at least 36,000 pesos.
To be eligible for appointment as administrator or assistant probation administrator, a person must at least 35 years of age, holder of master's degree or its equivalent in either criminology, social work, corrections, penology, psychology, sociology, public administration, law, police science, police administration, or related fields. Should have at least 5 years of supervisory experience, or be a member of the Philippine Bar with at least 7 years of supervisory experience. Regional Probation Office. Provincial and city probation officers. There shall be at least one probation officer in each province and city who shall be appointed by the Secretary of Justice upon recommendation of the administrator and in accordance with the civil service law and rules. The administrator shall have a technical service in the office of the administrator, which shall serve as the supervisor arm of the Board of Pardons and Parole, in the supervision of parolees and pardonees. The board and the administration shall jointly determine the staff complement of the technical service. The administrator shall likewise continue to cooperate and maintain a regional office in each of the administrative regions, including the National Capital Region, and also a probation and parole office in every province and city of the country. Regional Probation Office. Regional Probation Officer. The administration shall have regional offices organized in accordance with the field service area patterns established under the Integrated Reorganization Plan. Such regional offices shall be headed by a regional probation officer who shall be appointed by President of the Philippines in accordance with the Integrated Reorganization Plan and the recommendation of the Secretary of Justice. The regional probation officer shall exercise supervision and control over all probation officers with his jurisdiction and such duties as may assign to him by the administrator. He shall have an annual salary of at least 24,000 pesos. He shall have, whenever necessary, be assisted by an assistant regional probation officer who shall also be appointed by the President of the Philippines upon recommendation of the Secretary of Justice with an annual salary of at least 20,000 pesos.
Provincial and City Probation Office. Provincial and City Probation Officers. There shall be at least one probation officer in each province and city who shall be appointed by the Secretary of Justice upon of recommendation of the administrator in accordance with civil service law and rules. The provincial or city probation officer shall receive an annual salary of at least 18,400 pesos. His duties shall be two: A. Investigate all persons referred to him for investigation by the proper court or the administrator. B. Instruct all probationers under his supervision of the probation aid on the terms and conditions of their probations. C. Keep himself informed of the conduct and condition of probationers under his charge and use all suitable methods to bring about an improvement in their conduct and conditions. Letter D. Maintain a detailed record of his work and submit such written reports as may be required by the administration or the court having jurisdiction over the probationer under his supervision. Letter E. Prepare a list of qualified residents of the province or city where he is assigned who are willing to act as probation aides. Letter F. Supervise the training of probation aides and oversee the latter's supervision of probationers. Letter G. Exercise supervision and control over all field assistants, probation aides, and other personnel. And letter H. Perform such duties as may be assigned by the court of the administration. Qualification of regional, assistant regional, provincial, and city probation officers. No person shall be appointed regional or assistant regional or provincial or city probation officer unless he possesses at least a bachelor's degree with a major in social work, sociology, psychology, criminology, penology, corrections, police science, administration, or related fields and has at least 3 years of experience in work requiring any of the above mentioned disciplines, or is a member of the Philippine Bar with at least 3 years of supervisory experience.
So let's proceed to Module 7, Lesson 1, Forms of Executive Clemency, Pardon. Learning targets. Define what is pardon as forms of executive clemency. Discuss the procedures in granting pardon to qualified prisoners. To know the qualification in granting pardon. History of pardon. The exercise of pardoning has always been vested in the hands of the executive branch of the government, where the king, queen, president, or governor. The pardon dates back to the pre-Christian era. In fact, the Bible contains an illusion where criminal was released and pardoned by the king at all the time Christ was crucified. George Washington is the first exercised the pardon in 1795 after he issued amnesty to those engaged in Pennsylvania Whiskey Rebellion. Thomas Jefferson granted amnesty to any citizen convicted to a crime under the Alien and Sedition Acts. In England, pardon developed out the conflict between the king and the nobles who threatened his powers. Pardon was applied to the member of the royal family who committed crimes and occasionally to those convicted of offenses against the royal power. It is the general view that the pardoning power was the exclusive prerogative of the king. In England today, the power to extend pardon is vested in the Queen upon advice of the Minister of the Interior. It means the royal prerogative of the mercy is one of the historic royal prerogative of the British monarchy, by which they can grant pardons, informally known as the royal pardon, to convict persons. In the United States, pardon among the early American colonies was a carry over the England practice. The pardoning power was exercised by the royal government through the power delegated by the king. After all the Declaration of Independence, the federal and the state constitution vested the pardoning power of the President of the United States and the Governor in the federal and the state cases respectively. It means the prerogative of mercy, also known as the pardon power, has its roots in English history, where it the first emerged in the 7th century during the reign of the King Ain of Wessex. The pardon power continued throughout the American colonial period, despite increased abuses that eventually lead to the restriction on it. The President has the authority to grant a variety clemencies. There are respite, amnesty, commutation, and pardon. A pardon absolves an individual of penalty and reinstate all of their civil privileges. The pardon is the same as amnesty, except it applies to a whole group of people. What is the basis of pardon? Section 19, except in the case of impeachment or as otherwise provided in this Constitution, the President may grant reprieves, commutation, and pardons and remit fines and forfeitures after conviction by the final judgment. What is the effect of a pardon? While a pardon has generally been regarded as a blotting out of the existence of guilt so that in the eye of the law, the offender is as innocent as though he never committed the offense. The very essence of a pardon is forgiveness or remission of guilt. Next, it involves forgiveness and not forgetfulness. And lastly, a pardon looks to the future. It is not retrospective. What are the constitutional limitations of the grant of pardon? Limitations. It may not be expressed for offense in impeachment cases. It may be exercised only after conviction by final judgment. 3. It may not be exercised over civil contempt. 4. In case of violation of election law or rules and regulations, no pardon, parole, or suspension of sentence may be granted. 5th, and lastly, cannot be exercised to violation of tax of laws.
Good day everyone, I am Lauren II as Dolotina, and the science topic that I will be discussing today to you is about type of pardon. So first is conditional pardon, refers to the exception of an individual with certain limits or condition from the punishment to the law inflicts for those offense he has committed, resulting to a partial extinction of his criminal liability. So it is also granted by the President of the Philippines to release an inmate who has been reformed but is eligible to be released on parole. When a prisoner is pardoned under certain administrative requirements, like reporting monthly to a judge or a certain number of years. Nature of conditional pardon. A conditional pardon is in the nature of contract. It must first be accepted by the recipient before it takes effect. Pardonee is under obligation to comply strictly with the conditional imposed therein, otherwise is a non-compliance will result in a revocation of the pardon according to Article 95 of Revised Penal Code. It is a pardon violates any of the conditions of his pardon, he will be prosecuted criminally as pardon violator. Upon a certain conviction, the accused will be sentenced to serve imprisonment at a prison. Crucial, however, it is the penalty remitted by the granting of such pardon is higher than 6 years, and pardonee will be made to serve the unexpired proportion of his original sentence in Article 159 of Revised Penal Code. Next is an absolute pardon, refers to a total extinction of criminal liability of an individual to whom it is granted to any condition whatsoever, and restores to the individual his civil rights and remits the penalty imposed for the particular offense of which he was convicted. When a prisoner is pardoned and the offense of the penalties imposed on a criminal prisoner, it extinguishes and his civil and political rights are fully restored. According to in Article 89 and Article 94, the revised penal code states that a criminal liability may be totally or partially extinguished by the absolute or conditional pardon. On Article 36 of the revised penal code, pardon, it effects a pardon shall not work in restoration of the right of the whole public office or the right of suffrage unless such right to be expressly restored by the terms of the pardon. There is also exists pardon by the offended party under the Article 23. A pardon by the offended party does not extinguish criminal action except as provided by the Article 344 of the revised of this code, but civil liability with regards to interest to the injury party extinguished by his waiver. If only applies to the crime, it only applies to the crime under 344, like pardon granted by a chief executive. Pardon by the offended party does not extinguish criminal liability, although it may be constitute a bar to the prosecution of offender. In Article 344, prosecution of crimes adultery, concubinage, seductions, abduction, rape, and act of lasciviousness, the offended party cannot institute criminal prosecution without including both of the guilty parties if they are both live, nor in a case if he shall have if she shall consented or pardoned the offender.
Distinction of the pardon by the offended party and pardon granted by the President. Number 1. Pardon granted by the Chief Executive extinguishes the criminal liability of the offender but not in the pardon granted by the offended party. Number 2. Pardon granted by the Chief Executive does not include civil liability which the offender must pay, while pardon granted by the offended party can waive the civil liability which the offender must pay. And last, the pardon granted by the offended party should be given before the prosecution of the criminal action, whereas pardon by the Chief Executive may be extended to any of the offenders after conviction.
So, my assigned report is prisoners eligible for pardon. Number 1. Prisoners who are 65 years old and above, who have served at least 3 years of their prison sentence but no case shall they exceed 70 years old. Number 2. Prisoners who are invalids of afflicted with incurable or serious diseases. Number 3. Prisoners who are medically diagnosed as having at least 2 years of mental abnormality. Number 4. Prisoners who have served the following prison sentence. A. At least 8 years of their life sentence in case of simple crimes. B. At least 10 years of their life sentence in case of complex crime. C. At least 12 years of their 2 or more life sentence. The next is the purpose of absolute pardon are: number 1, to do away with the miscarriage of justice. The power of the President to pardon offenders on the grounds of innocence is rarely exercised because the criminal procedures are liberal in granting a new trial in the case of offender who are established his innocence after he has been found guilty. Only when the offender has no more legal remedy will pardon of this nature be given. If so exercised, absolute pardon is granted after an exhaustive investigation is conducted and upon recommendation of the Secretary of Justice. Number 2. To keep abreast with the current philosophy, concept, or practice of criminal justice administration. A criminal act, because of the changing scheme of social values, may become non-criminal at a later date. Therefore, persons serving imprisonment at the repeal of the law abolishing the crime may be extended absolute pardon. For example, a person is serving imprisonment for the black marketing of gasoline when his comedy was rationed. After the repeal of the law on black marketing be extended absolute pardon. The last is to restore full political and civil rights of persons who have already served their sentence and have waited for the prescribed period. The greatest number of applications for absolute pardon come from ex-prisoners who desire to be restored their political and civil rights. In the Philippines, the office of the president laid down the policy to grant absolute pardon to ex-prisoners 10 years from the date of their release from prison. Recently, the policy was released, thereby shortening the waiting period to 5 years. The waiting period is required to give the offender an opportunity to demonstrate that he has established a new pattern of conduct.
That's the end of our presentation. We hope that you learned something. Thank you for listening.
Now go.